was shared by the Honorable Darrell Vaz, who is the Minister of Science, Energy and Technology. And one of the key points that he actually mentioned, which I kind of alluded to earlier in my welcome, is that as individuals, we really don't pay attention to our data and the data of our customers, the data of our fellow employees, colleagues, etc. We don't pay enough attention to how that data is used and the potential dangers that are associated with living in a digital world. And so just to underscore what Minister Vaz mentioned, we want to first of all start with being accountable to ourselves and taking responsibility for how we operate and utilize and share our information online. So that was excellent sharing there from our Minister of Science, Energy and Technology. Now we're going to segue into hearing about Jamaica's Data Protection Act versus the EU General Data Protection Regulation. And that's going to be shared by Shavanice Arnold and Shireen Willis, who are Governance, Risk and Compliance Specialists with PLMC. Over to you, ladies.
Go ahead. Good afternoon, everyone. My name is Shireen Willis, and today I'm joined by my colleague Shavanice Arnold, and we are Governance, Risk and Compliance Specialists at Privacy and Legal Management Consultants Limited, where we are led by the exemplary M. Georgia Gibson Hendon. So we are going to focus on Jamaica's Data Protection Act versus the European Union's GDPR. Now, both the DPA and the European Union GDPR are legal frameworks for how personal data is supposed to be processed by persons or by businesses. So both acts really focus on what are data subjects. And data subjects are persons who own personal data. And personal data is any information that makes a person readily identifiable. So not only does both frameworks speak to what is a data subject, but it goes on to explain the rights of data subjects. So these rights include the right of access to personal data, the right to rectification, that is the right to have their inaccurate data being changed. Additionally, there's also a right to erasure, that is a right to be forgotten if it is that you don't wish for the data controller or the organization, for instance, to keep your data any longer. Additionally, you have a right to restrict processing, a right to object, and a right to receive access to your information in a readable format. Both legal frameworks also speak to the different data privacy principles. So the principles would include the fact that your personal data should be processed in a lawful, fair, and transparent manner. You should know how exactly your data is being processed. Also, another principle is data minimization. So that means that the organization, for example, that is collecting your information should only collect your data for a particular reason. Additionally, you have principles such as purpose limitation, accuracy, storage limitation, and respect for data subject rights. Both legal frameworks also include penalties. Now, these are very, very important, especially to companies, but also to individuals. And these penalties would include imprisonment, legal fines for individuals, and also for companies. Shavanice?
So essentially what Shireen is saying is that the Data Protection Act of Jamaica was basically modeled off the GDPR. So I think many persons would think, we're in good hands. So I hope that there will be enough buy-in from businesses, from sole proprietors, to say that it is important for you to prioritize privacy. And that is why we are here today. We named our conference Prioritizing Privacy because we realized that it is not so much about who is collecting the data or who is using the data, but more so about the data subjects. We have rights, and that is why these legislations have been put in place. Shireen outlined the rights to you, and further down, you're going to be hearing about incident management, and you'll see that you have a right to be informed. You will be hearing about data subject access requests. You have a right to access your information. So we want you to understand that we're not just doing this because we feel like doing this. We want you to see how important it is to you as a data subject, see how important it is to your organization in terms of being a data processor or a data controller. So we hope that you will take a lot from the presentations here today and leave prioritizing privacy. Back to you, Stacey.
Excellent. Thank you so much for that, ladies. I actually really like the that chart that you had there. If you could send that to me, because let me tell you, I am often asked whenever we're discussing privacy, the differences between the two, and Jamaicans sometimes like when laws aren't set just yet because they like the exception, to be the exception sometimes, and so and finding those loopholes. So it's nice to be able to say, no man, this applies to us as well. Or this is important for us to be considering as well. So I would love to actually have that that chart that you did up that really shows the connections. I think too that sometimes topics like this can come across very difficult to understand or challenging. And what I like about that is that you were able to go through and kind of speak to what each area represented. So thanks so much for sharing that. I appreciate it. And guys, if you're getting any questions while this is happening, I encourage you to drop the questions in the Q&A area or even in the chat. I see where Cherie is saying it's such a useful slide. Absolutely, Cherie. I agree with you. So go ahead, guys, and just drop your questions or anything like that in the chat so that we can take them at the end of the conversation. All right, so now we're going to move into our first presentation, and I'm really excited to welcome Mrs. Henlin Gibson for this discussion. Mrs. Gibson Henlin for this discussion. Georgia, I will say, has a stellar bio. Aside from being the Chief Privacy Officer and Chief Governance and Risk Compliance Specialist, she is also a Queen's Counsel at Jamaican Bar and is also called to the bar in Ontario, Canada, and New York in the United States. In addition to being an accomplished commercial litigator, she's a certified information privacy professional and a cybersecurity and technology law practitioner. So I love it whenever women can weave in all the different areas of expertise and things that they are excellent at. And I also want to share that Georgia is an absolute advocate for women. I can call on Georgia and say, Georgia, I need help, this popping down over here. So, and she's gonna find a solution. If she can't provide it, she will definitely recommend someone who can. And she's really an advocate for seeing us as women thrive and shine, especially in the space of technology. She sits as a member of the board or council for the Jamaica, what used to be the Jamaica Computer Society, that is now the Jamaica Technology and Digital Alliance, and supports us through not just advocacy, but also supports us with managing any of the legal issues that come up for the organization. And she's always available, makes herself available to me and the other members of council. So I just want to say, first of all, Georgia, big up yourself. You're doing amazing work. And thank you so much for continuing to advocate for diversity and inclusion in a space and an era that is so desperately in need of more amazing women in leadership roles like yours. So welcome to the stage. So Georgia is going to be presenting first, and her area of focus for today It's going to be on rights of the data subject. I think I got to that. Is that correct? No? That's what I saw on the agenda. Well, you can tell me what exactly it is.
Incident management for me.
Incident management. Okay, that was below. There you go. Incident management. Okay, my apologies. All right, awesome. Thank you, Georgia. And I will hand over to you now to speak to your area of focus.
Thank you so much, Stacey. I'm trying to get my slide up and running. And while I'm doing that, I want to say a few words about what we are doing and specifically what took place on Monday. So this month is not just Cybersecurity Awareness Month, it is also Breast Cancer Awareness Month. And that's a big part of why you see all of us ladies in pink, because it is to say and to show that we stand with our sisters who have, been through it, or those who are afraid and afraid to go and do the test, or having been diagnosed, are trying to struggle through. But Stacey speaks about me being amazing. Well, I can assure you that it is mutual admiration, because I was determined to wear pink today for Stacey as well, because Stacey is a breast cancer survivor. But you would never know. And even apparently while she was going through it, there's not a moment that she was down. So to the men and women on this program, I'm just asking you, however you can, to support creating greater awareness in breast cancer. Now, how amazing is Stacey? I like to read action novels, and I would sit and read them, and those books hold you. But Stacey actually wrote a book about her journey. And I kid you not, just as I would with my John Grisham, I sat down and I could not put this book down when she wrote about her journey. If you know anyone who is going through a difficult time with breast cancer, this book and the story of Stacey, one of resilience, one of struggle, one of strength, will help them to go through. So I commend it to you. You can actually reach out to Stacey to get a copy of this book. Now, so for this week, to the matter at hand, for this week, we thought that as our contribution to Cybersecurity Awareness Month, we would put on this session. And the two sessions were, as we indicated from Monday, slightly different from any that we have put on before, or most that you might have attended. And the difference is that we try to, in this seminar, to do deep dives into what you actually need to do in order to implement your privacy program. And so Monday was about that framework that you would set up in terms of defining your privacy vision, your mission, your program, who is part of the program, which models do you want to follow. And then Cherie, who I think is also online, had gone through one area, which is vendor risk management, and Kelly had done data mapping, and data mapping is actually where you start. So these programs during this week are really just to sensitize you, and they are the tip of the iceberg, really, because we really can't delve deep into it. And then, of course, we reached out for another phenomenal woman who is on screen, who at this hour, I think it's past her bedtime, but she's here with us, the DPO doctor, the thing that doctors do, right? Doctors come to the rescue. So we do have Samantha Sims with us from out of the UK, and I want to thank her in advance. So this is just one of the areas now that you would have to tackle and take on when you're dealing with your privacy program. Why would we want to talk about incident management? Incident management is extremely important because incidents are all around us these days. And even just a week ago, we saw an incident where Many people were affected. I don't know who wasn't affected. I think globally, everyone was affected in relation to that incident. That is the Facebook outage. In addition to that, we had our own incident last year, which is the Jam COVID incident. And I keep saying incident because that's important for what we are talking about, because there's a distinction between incident and breach. And that distinction is important because you're only required to report a breach, not an incident, and you have to investigate. But what you will see is that because of the reporting timeline, you have to have in place a plan, because otherwise you may end up reporting a breach when in fact all you had was an incident. And every time that you report the breach, remember that you also have to notify the affected parties, and that in and of itself can create panic and cause harm to your business and also consumer trust in circumstances where all you had was an incident. And so it's best in a real sense to be prepared to respond in the event that there is an incident. The incident timeline in Jamaica is 72 hours after becoming aware of a security breach, or of becoming aware that you process data other than accordance with any of the standards or obligations that are set out in the Act. So 72 hours is really not a long time. And that is the basis on which we thought that one of the things that would be relatable to you in the short time that we have to do these presentations is your incident management. How do you deal with that as part of your overall governance of your responsibilities? So I had indicated at the outset that there's a distinction between incident and breach. I believe that I said to you, there's a basis on which it is important to appreciate the distinction between them, because incidents are not reportable, breaches are. And a helpful rule of thumb in order to understand and appreciate this is that all incidents are breaches, but not all breaches are incidents. And a breach really takes place when there is when there's a likelihood that the personal information over which you have been given custody or control, or which you are processing, is likely to be affected. So it means then that in order to make that delineation at the outset and within the 72 hours that you have, it is important to have a process in place that will help you to deal with it in a seamless manner. There are about 6 or 7 elements that are involved in creating an incident response plan. I'm going to give it's really a top level overview of what is required. So in the event that you need additional information, I suppose it's at that point that you will consult with PLMC and its team. In terms of objectives and outcomes from this program, whenever you're doing an incident management plan, you are looking really to create a roadmap or a framework for reporting events and weaknesses. You are establishing a framework and assigning responsibility, procedures for response, and the collection of evidence. And you will be making recommendations for a data security incident and breach response. So in effect, what we are going to be showing you is how do you get to the place where you have that plan in place when you hear that there is an incident, that you can respond immediately and effectively. That will be discussed in the context of 4 elements, which you see on screen, which are to prepare, investigate, assess, remediate. You will hear persons speak about it using different words, but the whole point is that you have a plan which has these categories represented in one way or the others. These are not written in stone. So what is an incident management plan? The incident management plan is an organized set of strategies which you will develop to manage whether there is an incident or a breach and your reporting obligations to the information, the Office of the Information Commission. So we have indicated that the data breach is completely different, but getting there is a process, and that's what we mean when we talk about incident management. Now, what does that look like? What does that look like? So typically, you would want to consider these factors here when you are considering creating an incident response plan. You will have to look at what is the type of personal data that you collect, how you collect the personal data, what are the applicable laws, whether you share personal data with third parties, because remember that they would have to be involved in the event that there's a privacy incident or breach. And that is critical too, because remember, you have to identify at some point in the process the source of the incident or breach. And that is why all points at which the data may be exposed have to be incorporated within your incident response plan. You have to consider whether there have been previous incidents in your organization, what you learned from them, what you can do differently, is there any documentation, and so on. The roles and responsibilities of members of your team, activities that will trigger your incident response plan, and how you plan to report suspicious activities, and integrating the incident response plan with the business continuity plan. So a lot of times, and that last box or bucket is important, because a lot of times, especially now that we're talking about privacy, people tend to treat it as if it is this new thing that is mutually exclusive. But I believe that as you go along and as we get more accustomed to it in Jamaica, you will realize that even though it has to be focused and managed, it is something that has to be aligned with all of your other business functions, including to the extent that an incident can actually take down your business. And we saw that with Facebook. Facebook, in terms of their own business continuity, I mean, they had no choice but to remediate. But at the same time, they didn't sit back and say, oh, well, we have no way, for example, of communicating. They went on their competitor. It doesn't matter. Nobody's talking about it anymore. They went on Twitter and they advised us in their words what was happening. So for them, that was a total blackout. But in terms of their continuity, because remember, they want to come back up and continue. They want to come back up and have our trust. And so part of their continuity plan, for example, is communication. So when you're creating your business, your incident response plan, you realize that you need to put together a team. However, once you have that team, and we had discussed this team as an integral part of implementing your privacy program on Tuesday. Once you have that team in place, that privacy function must consider the following factors and more as the elements of your incident response plan. And what I'm going to do after this is to really just go through and to show you how these different elements will play out. So remember that what we are looking at really is a practical approach to the management of an incident. So yes, it is in the Jamaican Data Protection Act or the GDPR or any other data protection law that you are supposed to be reporting this incident. What we are trying to get you to appreciate is that this process is a process that is structured, focused, and strategic. You have to plan it. It has to be on your strategic plan. It has to be a part of basically your day-to-day outlook or function of that privacy department that we have asked and recommended that you add on your organizational chart. We are again indicating to you that what we have here is not written in stone, but we are saying that these are the basic or the general categories that you would have to consider as elements of your incident response plan. So we are now going to just do a little deep dive into what is entailed in preparation. So the first thing is that you are going to create your incident response team. That team is a core team. And that core team would include your privacy professional, security, and legal. You will see that this core team is a core team now that is going to determine once something happens, what are the other what other assistance do they need in order to implement this plan. An example of other teams that you will need or other considerations that you will need to put in place would be, for example, external security or forensic experts to assess the incident or determine the cause. And here's an important aspect of an external expert that you will require. You will require external legal counsel, and you will also have to determine through that counsel whether law enforcement must be involved or notified. Why would you want to have external counsel on board in relation to an incident when you have internal counsel? The reason is that every privacy incident or breach will likely result in litigation. And I say likely, it doesn't have to, but likely. Once there is that likelihood, you want to protect whatever discussions that you're having by legal professional privilege. This is not a time to get into an argument with anyone about whether your internal counsel is an employee and therefore not able to extend legal professional privilege to you. So part of your plan has to involve this kind of thought process where you know that you have an external counsel who understands these matters on your team so that you can benefit from legal professional privilege. And what legal professional privilege really means is that some of the things you do not necessarily, apart from the Data Protection Act, have to disclose them other than in accordance with the rules of court. In addition to that, you have to consider insurance, cyber insurance, and to evaluate if the insurance policies held by the company may provide coverage for any potential damages, and if not, to shore up those insurance policies. You have to talk about PR communications, and you will be hearing about the Facebook example a lot, and versus, for example, the Jam COVID response, because I am among the persons who would say that the response in relation to that incident was not handled in the best way possible, in the sense that even today, we are not sure if it was an incident or a breach. And the app is so important as part of our health control measures, and therefore it is something that in which we would want to engender trust. And it is also important because having regard to the concerns that were raised about personal information and informational privacy under NIDS 1. Now let us compare with messaging in relation to Facebook. When once we heard about the Facebook incident, we had our own views, and because of where the world is now, people would have thought that it was some kind of hack. But because they had their PR team and their engineer who is authorized to speak on their behalf, so they would in their plan, it appears to me, and I haven't seen their plan, but it appears to me that they would have had a plan in place and they would have designated persons who are credible and who are able to communicate their story as to what happened. I don't think I have read or seen much about that incident other than about the whistleblower since that day. So you have to have someone who is going to manage the internal messaging, and perhaps you'll also have the human resources to manager to ensure consistency in terms of delivering the internal message. One of the things that you want to ensure as well is that the roles of each of the team members are clearly defined. So you don't wait until the incident has occurred in order to determine who is going to do what. Everybody needs to know what they're responsible for at the moment of making that plan, because you are racing against 72 hours. The roles, for example, may include to maintain the privacy and security of the data, to document the extent and prioritize the impact of the breach, to identify compromised assets. You have a team to analyze incidents to determine the required and appropriate follow-up action. You have a team to conduct root cause analyses. You have a team to complete mitigation effects following on the incidents such as data loss or reputational harm. And you need a team that will communicate the organization status to the team. You need to define timelines for different peoples and for different persons and for different types of incidents. So for example, a response to a virus is not the same as to like social engineering or improper disposal of information or unexpected or unusual programs on your computer or lost or stolen computer or other equipment containing personal information. Some incidents therefore require a different kind of attention, a different kind of escalation. You have to map that path. And that is not saying, I'm not saying at all that you can plan for all types, but at the very least, at a high level, you would have a basis for saying or knowing where you are going at any particular point in time. And you have to develop incident report systems so that notification takes faster and goes through direct or structured channels. Every time, since I've been looking at privacy, including I suppose myself, one of the key things that I have come across is that training is ever so important. A lot of times you find that the employees have better things to do than to think about these incidents or breaches. And it's the only time it seems that some people want to talk about it or are aware of it is when it happens. So people have to be trained to be in ready mode and to be activated and to know how to activate the incident response team. So training is going to be very important. You can use different kinds of methods for that, like video scenarios and so on. And training will actually help each member, sensitize each member on the team and employees to identify threats. I think I have a text by Kevin Mitnick, and he writes a lot about social engineering. And he used to be a fraudster, eventually became, went on the FBI's most wanted list and then became one of the greatest resources as an expert to the FBI. And what he would tell you is that the weakest link in your organization is a human element. And to that extent, it is very important to continuously expose your employees so that you can reduce any gaps in the procedures or processes that are used in the organization, financial liability, regulatory exposure, or the cost of breaches. And also in the round, it will improve your brand and your reputation. So I just spoke to you about the systems that you would need to build and to put in place in relation to your incident management and how you would integrate the different persons. So a lot of what I have just said can be categorized into these three heads. The detection mechanisms. What mechanisms are you going to use to determine when an incident has taken place? Are you going to automate it, or are you going to have trained persons so that they can see when something is off keel or unusual? What about the reports? Aren't you going to have a series or a set of reports that will enable the intake process to be seamless and direct where the reports are channeled depending on the type of breaches, depending on whether it is a report of an incident from a client or a customer, whether it's a report of a potential compromise by a third party, or whether it is simply a weakness in the workplace. It is also important to understand and map the obligations. What do I mean by understand and map the obligations? So when we started out on this seminar this afternoon, you would have seen, for example, we compared with the GDPR and Jamaica. So for example, if we were to use those as areas in which you could have issues with breaches or data subject information, then you would have to know what the systems are. And that is why, as we stated on Monday, you have to understand the scope of your compliance. Which laws are you required to comply with? Because it feeds into all of the different kinds of plans and policies that you are going to be working with. The US is for example, is kind of difficult because US, generally speaking, does not have, not generally speaking, US does not have a federal legislation, like a uniform legislation that deals with data protection. It has sector-specific legislation, and some states have data privacy legislation, and I think the most known one is the California Consumer Privacy Act. So those are the little things that you will have to be looking out for. Now, let us say that you have done all that I just told you to do. Are you going to file it away so that it can gather dust? Or are you going to test it to ensure that when you are ready to put it into effect, it will work? So the best analogy that I can use for this, which I think is relatable, is a fire drill at school, where you would enlist, for example, the fire department, the health department, and all of those people. Sometimes, I think the last fire drill that we had in Jamaica probably resulted in an accident because it was a real simulation from the airport to the various hospitals in order to test whether, if an incident were to happen at the airport, how quickly they would be able to get people to the hospital or to first responders and so on. Same principle here. It is important to test the system instead of waiting until the date when the incident has occurred. And you can see that this recommendation, or this lovely chart here, we have credited Experian for it. I find it actually very useful, and I would commend it to you. And we would be using it in creating incident response plans for our customers. Now, after you have prepared your plan and you have tested it, I want to say that it is not just after you have prepared it that you need to test it. What you will find is, because of the accountability framework that is in the data protection legislation, there is going to be ongoing monitoring and there is ongoing accountability, so that when you are audited in the event of an incident or audited period, you should be able to say and demonstrate that you have a system in place and you had a system in place that, because that's some, if you look at the structure of the act in relation to the fines, they look to see whether you exercised due diligence, how the incident occurred, whether the incident would have occurred, notwithstanding all of the steps that you have taken. So it is important for you to have this chart as a guide, or something that looks like this, and it is tested on an ongoing basis, and depending also on the size of your organization. After you have made your plan or throughout, one of the things you may want to use as a continuous litmus test, as it were, is to ask yourselves these questions. Do you have an incident response team assembled? Have you audited the plan in the last 12 months? Have you identified third-party vendors and engaged in contracts with them in the case of a breach? Have you identified what your breach notification process would look like? Do you know what information your organization processes? And you see, I'll pause right there too, because as you can see, I am kind of demonstrating that the act is not, you can't do one thing at a time. Everything is intertwined and interrelated. So when I ask, do you know what information your organization processes? That is an important factor in your incident response plan. And the reason is that one of the standards, I think standard 7, that talks about, we call it for short, borrowing from the EU, privacy by default and privacy by design. And also built into that is that the systems that you need to put in for sensitive personal information is different from this, or different meaning stronger than the systems that you would put in for personal information. And that is because the likelihood of harm is greater, or the effect of harm is greater when it comes on to sensitive personal data. Remember that sensitive personal data is about sexual orientation, religious beliefs, political beliefs, health information, and all of those things. So that is why on your checklist, or when you're preparing that plan, you would want to know what information your organization is processing, so you can put it in the correct bucket and also direct the channel to the appropriate person who can most effectively deal with it in the event of a breach. Now, let me just move quickly to another element in the plan, which is to investigate. When you're investigating, your investigation will likely be in 2 parts. First, you'd want to interview, as it were, the business user who is reporting the incident, and then submit the results of that interview or interaction for review. And the second part of what you're doing would be that the privacy and security team would be looking also at the incident, but from a different angle. So just let us look briefly at what we would be looking for from the business user as one collection point. You would be looking, as you can see, on what the cause of the incident is. You'd be looking to see what information was discovered. You'd review the information so that the time of the occurrence or other information relevant to impact or remediating the incident can be examined. Also bear in mind, as I said before, that the laws, even though they are territorial in scope, they can have some global reach. And that is the reason that you would want to first interview your business user. Is that business user in Jamaica, or is that business user in the EU? And what steps will you need to take to inform or notify those other regulators, or whether you're informing just your local regulator? So if you have EU subjects, then you know that you have to inform the local representative, so that the local representative can inform the Information Commissioner's Office in the UK. You have heard from our update that we are well on the way, and that by December 1, we will have in place the Office of Information Commissioner. Now, we looking at the second bucket, which is privacy and security. So the privacy and security team will be determining whether the breach was by a controller or a processor. Remember, if you recall from the chart that you looked at at the beginning of this presentation, the controller is a person who determines how the data is to be processed, or if it is to be processed, and the processor is the one that interacts with the data and the instructions of the controller. But in the Jamaican Data Protection Act, can't figure out why they omitted it, but the obligation for compliance is really on the controller. Now, the reason you want to talk about it, so in Jamaica, it's controller. In the EU, it is controller and or processor. So you need to know in terms of scope, because if you are processing EU data's information, EU data subjects information, you're going to realize that both processors and controllers need to be on their guard. If you are processing only in Jamaica, the controllers need to be on their guard. And even before that, they would have had to have a contract with the processor that mirrors their obligation, so that the processor will be as agile and alert in the event that an incident has occurred. So it is the privacy and security team, though, who will be in the best position to assist you to determine whether we are dealing with an incident, a potential or actual breach, or nothing. And they are the ones who are best placed to activate the plans to mitigate and to determine as well, help with the determination of whether the breach or the incident involves third parties such as vendors. And I think we were very strategic in this seminar, in these webinars, in ensuring that we looked at the vendor risk management, because you will see how many times, quite apart from employees, we have been mentioning external partners such as vendors, because sometimes the vulnerabilities or the issues that affect data come through vendors. I think that was the case with a Target breach some years ago, where the breach was caused through the AC vendors. So now, having dealt with the question of having looked at it and investigated, what you are now going to be able to do, because you have now gathered the information, is to make an assessment. Remember, all of this is taking place within, mind you, it says within 72 hours after becoming aware of the breach. But that don't mean you can take all the time in the world to be determining whether it's an incident or a breach. You don't have that luxury, because you really need to cauterize the effects of whatever it is. So the assessment, though, will involve the risk, if any, in relation to other laws. Again, you're seeing scope of laws, or which laws you are impacted as being an integral part of what you are doing. You have to determine the severity level, you have to determine the notification requirements, and you have to check processor or vendor obligations. So you see that what is the notification if it is found that other jurisdictions are affected, what are you going to do? And so your list now should begin to consider what you are going to do to ensure that remediation and notification requirements are met, and that you have to place the incident into the boxes or buckets to determine the remediation plan. So a box or buckets would include sensitive personal data versus personal data, EU data versus California data versus Jamaica data. Those are some of the ways that you will be assessing, and all of this, I presume, will be going pretty fast, because you want to ensure that your systems are protected, your reputation is intact, and any compliance investigations that you have will be met. One of the things that you'll be doing at the same time is that you'll be trying to remediate or put into place methods for recovery, that is to get your systems back on track. So you would have to consider some of the following questions. When can the systems be returned to production? And this is why I remember we spoke about the plan above, where we show that you need to do the little drills and so on. One can never plan for what a data incident is going to look like. Probably you plan and the incident that comes does not look like it at all. Or probably you plan and you never have a data incident, so you may think that you can relax, which is like how I felt in 1988, or Jamaica felt in 1988 when Gilbert came, and we said, sure, no hurricane now come, it never come yet. And my generation never could understand why people sing about 51 storm, them never born, because we have never experienced a storm, and every storm that we hear that is on its way never made its way to Jamaica until Gilbert hit, and it was devastating. We were unprepared, we were on the road going about our business, and it hit harder in modern times than it should have. So if we think about that as an example, we can think about the fact that if we allow an incident to take place without asking these questions and without testing the system, the ability to recover from whatever it is, that whether it's an incident or a breach, that recovery process may take longer. So you must ask yourself, when can the systems be returned to production? Have systems been patched, hardened, or tested? Can system be restored from a trusted backup? So backups and redundancies are important. How long will the affected systems be monitored, and what will you look for when monitoring? What tools will ensure similar attacks will not occur, and such as file integrity monitoring, intrusion detection, and so on. Then we spoke in passing about this. Well, from the beginning, we keep talking about this, but of course, it will have to be a part of your plan. So you see, we are saying here and confirming what we've been saying before, that you would have to notify the commissioner within 72 hours of becoming aware of the incident, of the breach. It says breach incident there, but you know that I've been saying it is of the breach. It is breach that is that triggers the reporting requirement, not an incident. Just to be clear, notwithstanding that you are seeing aware of breach incident on the screen, what you are to report is becoming aware of a breach, and that you have to deploy your forensics and conduct your investigation with deliberate speed. So the report from the commissioner too, and that is why the plan is important, because it's a detailed report that is required. So I'll just run through quickly what some of those factors are. They're actually in the statute. So you will see that you are required to state, and this is why here now you will see why it is so important to have your plan and to know the investigation that we spoke about, the investigation dealing with the business user versus the assessment by the privacy and security team, because the report requires these things. What are the facts surrounding the incident or the breach? Well, breach, the nature of the breach, the number of data subjects concerned, the measures to mitigate the effects of the breach, consequences of the breach, the type and amount of data concerned, and the name and contact information of your DPO so far as relevant. And remember that I had indicated on Tuesday that in the past it was quite commonplace for me to say to small and medium enterprises in particular that you did not need to appoint a DPO because it's optional, and it's only if you process certain categories of data, which would include sensitive personal information, or you're a public authority, or you publish your process or intend to process large amounts of personal information. But with COVID-19, that has changed. And so a lot of us will find that we are engaged in taking temperature every day, contact tracing, COVID-19 tests, and so on. So invariably, certainly the environment in which we now exist may require everyone basically globally to have to name a data protection officer. And there's a plug for PLMC here that, fortunately for you, PLMC offers DPO as a service. So, quite apart from your reporting obligations, and naturally, you don't want this to happen again, and you're going to learn from what you're doing, what you did not do well. Because again, using the Gilbert analogy, I can assure you that since that time, generally speaking, whether as a people or as a country, we learned lessons from Gilbert. We have been more prepared, our houses are more resilient, and we would, generally speaking, honor the directions to evacuate. So we learned. So similarly, in relation to your incident response plan, you need to be able to document and chart, what changes will need to be made to the security. Those are considerations that you're talking about in advance that you will have to consider when you get to the place of dealing with your incident response plan. How should employees be trained differently? What weakness did the breach exploit? How will you ensure a similar breach doesn't happen again? So let me just take you back a little to how should employees be trained differently. Here's why that is important. We have been doing a lot of training in one of the implementations that we have been doing, and we do the training in different ways, and most times probably like this. And one day we realized that some persons were not getting it at all. And so what we decided that we would do is, for example, change the training to how people learn. So some people will learn because you are giving them some fact patterns and some videos or scenarios instead of sitting down and talking to them. And that's what we did, and it actually worked. And so you always have to test the temperature of that room in terms of how do your employees receive information, how do different categories of your employees receive information. One of the scenarios that we have sometimes that we share with people, for example, is in relation to even just the garbage collector. When you say to the garbage collector, here is a bag with garbage or waste, and there is a secure site out at Timbuktu or Moko, as we like to say in Jamaica, where you are to take this. Is he trained to understand that if we say you're to take it to Moko, take it to Moko? Because if you don't take it to Moko and you leave it right down, just throw it away on the street, personal information could be lost in that way and you could be in breach. So don't think that any category of your employees should be exempted from this training. You really have to think it through all of the data management life cycle, we like to call it. So you have to consider also some damage control. You have to assume that news of the incident will be leaked. Focus on initial media statements on the steps being taken to investigate the issue. Sounds like how Facebook handled themselves to you. So I'm going to start over. And while I'm going through this, I'm just going to ask you to think through what you think you saw with Facebook. I am relating this to Facebook, and frankly, I believe that they did it well. So assume that news of the incident will be leaked. What will people's impression be? Focus initial media statements on the steps being taken to investigate the issue. When more information is available, provide details about what happened and what steps consumers can take to protect themselves. Communicate with the commissioner as soon as possible and ensure that frontline staff are aware of what information that they need to communicate, and they should redirect specific questions to the incident response team. And that is because you want to ensure that there is a uniform message and that the only message that is out there is a message that you want to communicate. And that underscores significantly why you need your plan, your incident response plan. Remember that data protection, generally speaking, is all about the protection of the information. So probably one of the most, although everything is important, one of the most significant things that you can do is probably this incident response team and incident response plan. What are the benefits? Of course, organizations avoid litigation exposure, non-compliance, reputational liability, potential regulatory scrutiny, loss of revenue, loss of business, sanctions, and negative press. And I'm going to flog it to death. Facebook, the Facebook example, when 70 million people go over to Telegram, when some people say, like a jewelry company actually said, I'm going to find a place to do my other business. And remember that with Facebook, even though they say it's old people who are on Facebook, but remember that it was the entire, they're interconnected social media platforms, which include Instagram, which is where most young people are, apart from the other one, that's TikTok. But so to the extent that everything was affected, people were actually looking for alternatives. So that is why it is important for you to have this incident response plan. And it seems to me that in this incident response plan, even though I deal with it so far down at the end, and which is why it's important to have it, that communication and your messaging is going to be the key in that plan. Thank you so much.
Oh, excellent, excellent presentation from you there, Georgia. There is actually a quote that I fell in love with last year when we were in the midst of the pandemic, and it is actually related to something that you said early on in your presentation. And the quote is from Alvin Toffler. It says, "The illiterate of the 21st century will not be those who cannot read and write, but those who cannot learn, unlearn, and relearn." And I think it's so critical for us to recognize that we have to start really understanding new principles and practices in this digital age. So thank you so much for that presentation. We're now going, go ahead.
Stacey, before you move on, I saw that Dustin Fraser just said excellent presentation, but it's not just that Dustin Fraser is saying excellent presentation that I'm calling him out. Dustin Fraser is now Dr. Dustin Fraser. He just defended his thesis a couple of weeks ago on cybersecurity in incident in Guyana, where he looked at the entire Caribbean. And we have to give a shout out to our people, male or female, when we see that they have done well and that they're doing their research and so on. So congratulations, Dr. Fraser.
Congrats, Dr. Fraser. And thanks for joining. Thanks for taking out the time to join. Well done. Excellent. So yes, and there were a couple of things that I think are also key for us to recognize when we're talking about incident response planning in particular. At one of the companies that I work with, ICD Group, we recently had an analysis done, an assessment, so to speak, of our readiness for taking on data privacy protocols and building out a framework. And I must say that just being able to identify the different categories of data and the risk levels associated with how we actually manage our data was very enlightening, not just for me, but for the entire executive team. And so when you're thinking through incident response, you really have to start off with that checklist. You know, what are some of the things that we need to be looking out for? What are some of the things that are really critical to the way that we do business and with the way that we manage data? How do those two things relate? So having those check boxes, like, I mean, I think you guys should actually use that as a lead generator in the top of your funnel. Just give away a free checklist so that people can do their, like, a self-assessment, you know, because I don't think we are aware of what it is that we're doing that may actually end up hurting us in the long run. So that, I think, is critical. I also really liked that you touched on the benefits of the incident response planning, because when we think about data privacy, it sounds very far off. It sounds as though it's not something that is applicable to you, as you say, until something happens out there in the world and you feel like, oh my gosh, I need to check on this, right? But the truth is that as organizations, as companies, especially the large companies, you can really experience some significant risks if you are not managing data privacy and protection properly. And for some small business, you could have one breach and it ends up, or incident, that is interpreted like a breach, and it could end up, causing your business to collapse, right? So I really like the way that you were able to kind of frame that and walk us through it, and then show us the benefits or the risks that we're going to mitigate by actually addressing incident response. So thank you so much for that, guys. Make sure that you are, you're putting your questions in. If you had any points that Georgia raised during her presentation that you want to have answered, jot them down, drop them in the chat. We also still want to welcome your comments as we get ready to move into our second presentation for this evening by Samantha Sims, the DPO doctor, which is all about handling data subject access requests. Because yes, I'm planning a conference right now, Samantha. And let me tell you, I have a line out the door for all the people that want me to share the conference people, them registration information. So I am very keen on hearing your presentation so that we can have a discussion about it. And there are so many companies out there, marketing agencies and different types of entities that have events. And all events are virtual now, predominantly virtual. And I don't think they're thinking about something like this, right? So over to you, Samantha. Really looking forward to this discussion.
Thank you. Thank you very much, Stacey. So thank you and good evening to everyone. If you can see that I'm plunged in what looks like darkness with a shadow behind me, it's because I'm currently out in the UK and it is quite late my time. However, this is my subject. This is what I love. I've been in privacy for 20 years, and data subject access requests actually is an area that I started off working on. So we're going to go into this. I'm just sharing my screen. Excellent. So it's wonderful to be with you all this evening. And what I'm going to do here is take this a little bit more from the abstract, because we've been talking about data protection and we've been talking about incident management. Incident management and subject access, or managing individual rights, is actually, or are actually, some of the most challenging areas that a business can face. Why? Because they in themselves are incidents, and they are something that, although you can prepare for, they often are unexpected. And this is what makes it quite difficult for organizations. So when we're talking about subject access, we are talking about a right under data protection laws. Data protection and data privacy are more or less synonymous. When we usually talk about data protection, we think about it in this modern sense of protecting data physically. However, the origins of data protection law isn't about the protection of the data physically in terms of the security of the data, as we've been talking about in terms of incident management. It's about the protection of an individual's rights. It's about how to be able to control or have some kind of visibility into how your data is being used. Where's this come up from then? Well, actually, let's take it all the way back. We talked earlier about the GDPR and the Jamaican Data Protection Act, and we looked at the comparisons between those, in particular in respect of the rights. However, the data protection laws as we understand them today actually emanate from World War II. They were created as a way to prevent against the discrimination that took place in Europe during World War II. So when we're talking about data protection laws, it was the right of individuals to be able to protect how their data was being used. Because at that time, individuals were being discriminated against based upon their race, their ethnicity, their gender, their religion, their sexual preferences. And so that's why we even see this higher tier of data that we're now calling sensitive personal data receiving extra protection. So really, what we are talking about when we're talking about individual rights is the protection of your rights. That's what we're talking about when we talk about data protection in general, more widely. And security does form part of those rights. But we're going to really focus on the rights of subject access right now. And taking it back to World War II, let's think about why that particular part was important. Well, it was really, really important because during World War II, there was the systematic collection of data by the state. And people were not able to have visibility into why, how, when, and what data was being collected. So that's why individual rights actually form the cornerstone of data privacy laws. And yes, we've become very concerned around the physical security of the data, but that is something that we tend to look at at the end result, and it is something that we hope will be less likely. But giving individuals the rights to over their data is extremely important. And so that's why we see that reflected very early on in the Jamaican Data Protection Act. The Jamaican Data Protection Act actually takes on a number of the rights that we see in data protection legislation in Europe. Some may say that the General Data Protection Regulations is actually the basis for what the Jamaican Data Protection Act has become. But actually, when we look at it, we see a lot more similarities with the UK's Data Protection Act from 1998. And we see a number of those features repeated, even though that act was based upon the directive in Europe. We're seeing what we see in Jamaica is often a lot more akin to what we're seeing in the UK. And there's a good reason for that. Jamaica, like the UK, has a Commonwealth, a common law system. And that common law system means that there's a lot more similarity in our approach to managing some of the legal aspects, including individual rights and the right of subject access. So the Jamaican Data Protection Act gives us, as I said, a number of rights. So we see the right of subject access. It's an incredibly important right, one that's been long-standing and has been heavily tested in the UK and in Ireland, not so heavily tested elsewhere. And then in the US, we do also see some elements of subject access. We see it in the Healthcare Privacy Act, HIPAA, that allows individuals to have visibility over their data. So this isn't completely new to Jamaica because we do see features of it in other areas, but it certainly as a holistic package, it is going to be a very new thing. Other rights that we see is the right to restrict processing. What does that mean? Because it restricts processing? Well, essentially it means that you can ask for organizations in certain circumstances not to process your personal information. It doesn't apply across the board. For example, if I make a payment, I can't just say before the payment goes through, hey, you got to stop now. You can't use my personal information. And then the transaction doesn't go through. But it's a general right, which is, I'm pleased to see, was reflected in the Jamaican Data Protection Act. We also see the right to object to automated decision-making, which is, I think, again, another very important right in today's modern society, because as we're moving towards, in our digital society, as we're moving towards the increased use of artificial intelligence and other methods of profiling individuals based upon using automated decision-making, it's going to be even more important that we're able to ask that there is human intervention in our in decision-making about us. It will help us in preventing against algorithmic bias and making sure that there is actually an individual who's accountable for our making decisions about our data. And we also see the right of rectification, or the right to have the data rectified, reflected also in the Jamaican Data Protection Act. So not all of the rights that we see in the GDPR have been carried across, and also the rights that we saw in the directive before. But some of the most important ones have certainly been carried across. And what I'm going to focus on today is, as I said before, the right of subject access. Why? Because it's a right that we all have. It's the right that we have to be able to know what information is being used about us, how it's being used, and also to even have a copy of that information. It's also the area, as I mentioned at the top of the presentation, it's the area that businesses seem to grapple with and really find challenging. because there are time limits associated with that, the right. Now, this subject access right is essentially a way for organizations to demonstrate their compliance with the accountability principle and the transparency principle. It means that organizations have to show that they are doing the right thing and that they are seeking to comply with the rights of the individual when handling personal data. Accountability is an extremely important part of the modern data protection legal framework. Without accountability, the whole thing falls away, because we have that data controller who must be responsible and accountable for the processing of that personal data. And that's why we see, again, in the Jamaican Data Protection Act, we see that former approach that we saw in the UK Data Protection Act and also the Data Protection Directive before the GDPR, that the data controller is the party responsible for the processing of the data, and not so much the data processor. And so that's why we're seeing that carried forward. And so in Jamaica, it's going to be important that the data controllers are accountable to individuals and ensure that they are able to meet with individuals' rights. So when would you make a request? Well, for example, if I was someone who had been traveling in or out of Jamaica during last year, I certainly would be making a request to any organization who was collecting my data because of the Jam COVID incident. I would want to know what data you hold on me, how it's being held, why, and what happened with my data. In terms of transparency, the right of subject access also reflects the information that we have in our privacy policy. So tracking back, one of the most important features of data protection law is the right to know what data is being, how your data is being used. And the very first place that we're supposed to know how our data is being used is in the data privacy policy. And then in that data privacy policy, we are supposed to be told how we can find out more information about how our data is being used. And through that, we can then start to look at how to make these requests for our data and receiving a copy of the data. Now, the Jamaican Data Protection Act, similar to the GDPR, allows 30 days for a company to respond to a request, as long as there are no exemptions or any exemptions that allow them to extend the timeline. Now, this can be very, very difficult for businesses, and having explained what the right is and why it's important to individuals, I want to talk about some of the big issues that companies actually face when handling this right of subject access. So the very first thing that we look at and we think about as an organization going through a subject access, and I'm going to take you through some of the implementation steps a little bit later and some of what the process looks like. But let's just dig into some of these big issues, because they are real challenges. It can be very, very complex. So we receive a written request, because it has to be in writing under the Jamaican Data Protection Act. So we receive a written request from an individual, and it can say anything. For example, I have seen requests that say, I want to know everything that you hold on me. That is a very wide scope for a request. And data protection laws do not allow us to be to ask why usually the individual wants the information. We have to be agnostic when it comes to supplying that information, usually, but for certain exemptions may exist, for example, where we may be considering if they are legal proceedings against us. But in the main, the scope of the request, the permitted scope, is very, very wide. And so it can be really difficult for an organization to comply with that type of request, because the organization has to search a number of data locations in order to identify that information. So when we're trying to look for this information, we're going to be looking into structured filing systems, which are by and large going to be automated filing systems. And making sure we know where that data is, identifying the actual data locations, is one of the biggest challenges that an organization can face as well. But taking it back to the scope of the request, sometimes we may want to seek a way of limiting that request so that we can find the information more easily. So we need to develop ways in which we can speak with the individual in order to try to identify what they really want to know, so that we can guide them towards the right information. The scope of the search is one of the areas where we struggle a lot, because data protection laws actually, as they've developed and as common law has developed, certainly over here in the UK and through Europe, the scope of the search can involve what we call a disproportionate effort. But there's a very fine line for what would be considered a disproportionate effort. So the scope of the search means that when somebody's asking for the information, where are we going to look for that information within the universe of information that we hold as an organization? Nowadays, with so much automated processing, the way that the way that these laws were designed in the first place were actually not taking into consideration originally the fact that everything would be on computers. This right of subject access has actually been in place since around 1984 in the original data protection laws from around 84. And it was actually first discussed in 1980 as a formal requirement under the law. And at that time, we didn't have computers in the same way. So the scope of search was far more limited. Today, the scope of the search can involve our archive system. When I say archive system, I mean our computer archive system, because we'll be looking into the document repositories, we'll be looking into the email repository, we may be looking into any centralized filing system, for example, our HR filing system, but also we will look into our third parties who are holding data on our behalf. And it's important that we're able to gather this information within the time limit so that we can provide that response back to the individual. So the scope of the search is something that we really need to prepare for, because it can be, as I said, so wide. And to give you an inkling as to what would be considered as a disproportionate effort or not, there are court cases where it has been decided that in the main, you would need to go back into the archive and also back into the backup systems. However, as a rule of thumb, I typically advise clients, and I have done for quite some time, that actually the scope of the search should be information that we would use about the individual. So if we're not using the information, it just happens to be there because the backup tape has run and we have it in the backup, then I would consider that we do not need to include that in the search. And that theory has been tested, and it has been proved to be compliant. But my litmus test for all clients when handling these issues is, if you were defending yourself against that individual, if they were raised a litigation against you, would you pull that information back up and use it against them or to defend yourself? If the answer is yes, then the information goes in. If the answer is no, then we can say the information stays outside of the request. The other area that is really difficult for organizations to manage is disclosure. Because when we get back this wealth of information, we now need to decide what would be disclosable to the individual. There are a number of exemptions to disclosure, but in the main, unless there is the information about a third party who has not consented to their data being released, unless the information is the information doesn't compromise any confidential information of the company itself, intellectual property. In the main, the information will need to be disclosed. As long as it is biographical information about the individual concerned, that information will need to be disclosed. And that can include some really embarrassing information. There are times when I've seen emails from clients and I think, did you really write that? For example, I once read an email from a client who had received a subject access from an employee, and the client had actually said, yeah, let's give her the bullet. And that email had to be disclosed. And so it's really important that we are willing to we have a good relationship across the organization to make sure that the information that needs to be disclosed is actually disclosed. And this is where it's important for that privacy person or whoever is handling the data subject access requests to be able to be independent enough so that they can make the right decisions and be good bastions of data privacy and data governance within the organization, rather than find themselves having to be influenced by the powers that be, maybe in an organization, and not being able to disclose that particular piece of information. And disclosure is actually one of the areas, disclosure for subject access request is one of the areas where we can really see a challenge from the regulator. Because if an individual feels that not enough information has been disclosed to them, they will complain. And oftentimes, when I've seen audits by the regulator, they have emanated from a complaint relating to disclosure of information that somebody thinks was not sufficient. And now the client is being audited by the regulator. And I tell everyone, an auditor is going to find something wrong. It's just standard. Nobody's perfect, so they will find something wrong. In fact, just today, one of my clients that I'm dealing with right now is actually in the middle of a complaint to the UK's regulator, and it all emanates from an email that somebody believes should be deleted, and that the email has not been deleted. And that person is now making a complaint against a very high profile organization in the UK. And as I said, this is an area where we start to see more challenge by the regulators, because upholding information individual rights is, as I said, the cornerstone of data protection law. Another big issue for companies or organizations to consider is the operational cost of managing data subject access requests. because they might sound quite easy to do, but believe me, they are not. 30 days is not a long time when you have to liaise with the individual, identify the information, locate it, and then also prepare the information for disclosure. So, and on top of that, this is a whole new stream or a whole new operation for a business. The estimated costs for dealing with the subject access in the UK, certainly at about 5 years ago, we estimated it cost roughly £6,000 per request. And that's for the slightly more complex requests where we had to go through these processes. I've seen requests that can cost up to £25,000. I've also seen requests where businesses choose to actually pay out the individual instead of, and especially when it's related to an employment claim, instead of honoring the request. Why? Because those organizations were unprepared. They did not have the operational processes in place to manage data subject access requests. And that's why it's important for every organization to really look at their policies and procedures in advance so that they make sure they have covered off the requirements and they have a documented and communicated process so that individuals are able, so that the organization is able to respond to those requests in a timely manner that also protects the organization. So some of the things that we advise clients to look at when implementing a subject access request process is, what do you need to do at the beginning? How do you identify that the request is even from that individual? Let's not get into the problem of, you've actually provided information about one person relating to another, about one person to another person because you've been duped into providing that information. Sounds abstract, been there, seen it happen. We've got to make sure that that request is clear. We've got to make sure that in the main, we have to make sure that it's personal data. It's actually data about the individual. So going back to our definition of what is personal data and making sure that it's actually their biographical information. Typically, these incidental references won't really apply. It's got to be about them. We need to make sure that we've received the request in a timely manner, that it's come into us, because once it's come into the organization, that request is deemed as received. So we need to make sure there's a process that it goes straight through to the right person. And sorry to pick on JamCOVID, but what was actually the crux of the issue there? It was that the first time that TechCrunch contacted them, the notification went to the wrong place. It took a while for it to get through to the right person. And that lapse of having a process in place to make sure that the communications go to the right place can cause many problems. So making sure that we've got everyone in the organization trained to recognize a subject access request so that it goes right to the correct person is extremely important. And also we need to make sure that we've actually agreed with the data subject what information we're going to be providing to them in terms of what was their request, and this is the and how we're going to go back to them within the 30 days with the information that completes their request. In the search process, we need to make sure we've got systems set up so that we can locate that data. A little bit later on, I'm going to go through a bit of a checklist of what you need to do to prepare for that. We need to be able to redact the data, make sure that the data does not contain information relating to trade secrets, intellectual property, third-party information. We also need to make sure that we have communicated with third parties who may have provided the data to us. For example, what we often see is where someone has provided a reference or an opinion about someone, and we are about to disclose that information. We need to consider their rights, their privacy rights, against the rights of the individual who is seeking to access their data. And so we need to be able to have systems in place, or I should say processes in place, to make sure that we can do that quickly and within the 30 days. Because although we may be permitted to extend our timelines, we shouldn't be doing so as a matter of course. An extension to a timeline is something that we should be seeking to do only where it is absolutely necessary. And as we go through that information, we have to be able to make copies of the information in sufficient time so that the individual can have access to that data. This is a very lengthy process, and it's very important that we actually have a process in place to make sure that we can handle this. Otherwise, it can become very burdensome for an organization, and also it can become a situation where the executives are uncomfortable, staff are uncomfortable, everyone, to be honest, becomes really uncomfortable and almost goes into a panic when they see that a subject access request has come in. And the way that we are talking about subject access requests, I think it's really important to understand the volume of subject access requests that can come in when individuals know that they have the right to make a subject access request. I can think of organizations, many organizations, who have whole teams dedicated to responding to subject access requests. That's all that they do. So it's really important to remember that when we talk about a subject access request, you may be thinking about it as, oh, one request will come in. On average, most organizations, even smaller organizations, will receive perhaps maybe 5 to 20 requests per month if they are interacting with a lot of personal information. But the bulk of subject access requests, in my experience, unless you're a large kind of retail organization, the bulk of your subject access requests will come in from employees, and they will be related usually to some type of employee grievance. And that's what makes the subject access request rights a lot more challenging and complex for organizations to manage, because the right of subject access is agnostic. It is not something that we're seeking to, as we said before, it's not something that we're seeking to understand exactly why they want the information. And so we still have to be able to protect ourselves whilst we are, as an organization, honoring that request. So it's really important that we have a process. And this is the process that we pretty much recommend to our clients at the Information Collective. And this is based upon my experience of developing these request processes for organizations over more years than I care to say. But it's really important that we have a request that works with the organization's existing operational procedures, and we can make sure that the organization is able to bolt that in to its processes and be able to respond to those to those subject access requests. Now, this will build over time, and I don't expect any organization to get here straight away. But there are some things that we really need to think about as we are implementing subject access requests. And I think, going back to something Georgia said earlier today, I think this is a really fortuitous time, an excellent opportunity, because whilst the law is not yet fully enacted, we can start to prepare. And so the best way to prepare is going through this checklist. If you have a centralized and searchable filing system, you're going to be able to find your information much, much quicker. We won't be looking in all these different little pots to try and find the information to complete the request. If we have data retention policies and procedures in place, we will know what information we are keeping and for how long. And that way, if someone says, I would like to know how you were using my personal data relating to my tax claim in 1998, we can say, actually, we didn't store that information. We don't store information from 1998. And we can promptly respond to say that we are not holding that information. Because if our data retention procedures are running correctly, we would have deleted that information. We also need to have a data inventory. A lot of people think this is also a data map. It's not quite the same thing. The data map shows us the flows of the data across an organization and out and to its third parties. But the inventory really is almost like an asset register. It tells us what data we have and where it is. It's not necessarily concerned about the flows, but it talks a lot more about how we're using that information. Something else that's really important to look at is to know what is the lawful basis for holding that information. Why do we have it? Because that will dictate some of the rights that are attached to that information. So for example, if we need to keep information about an individual for legal reasons to comply with a statutory duty, then in most cases, we are not going to be able to prevent the processing or even delete information. We will need to keep that information. Whilst, and in some cases, we may not even be able to share the existence of that information, depending on what it's relating to. So for example, let's just say you have been requested by a government department or requested, sorry, by a law enforcement department to provide information to them about an individual. That may not be something that you are able to share with the individual if they request it. So it's always important to understand the lawful basis for keeping personal information. We also need to make sure that we have consent management procedures in place, because oftentimes the subject access is actually used to make sure that we are honoring and we're being accountable to the individual in protecting their rights. And so somebody has the right to the right of consent, and they have said they do not want their data to be stored or to be processed for a particular reason. The subject access will flush out if we're not doing that correctly. So that's why it's very important to make sure we have these consent management procedures and systems in place to be able to honor those consents or those opt-out rights that we may be given to individuals. We need to make sure that the actual process is documented and communicated. There is no point in drafting a nice and pretty process for managing subject access if we don't communicate it across the organization. And then when the first request comes in, everybody jumps up in a flap. It's extremely important to make sure that everyone is aware of their rights, but also aware of the fact that this can come in and we need to honor the rights of the other individuals. We also need to make sure we have dedicated personnel. That might not just be one person. It can be that across the organization, we have identified people who will be responsible for receiving, for searching, for collating, and also for disclosing that information. We need to make sure that that is already within our process, so that we, again, will not be flapping for those 30 days when we are panicking and trying to respond to that data. And lastly, we need to make sure we have the correct budget to put all of this in place. Because without parking the operational expenditure for this into the budget, we will not be able to comply. So we almost need to make sure that we are foreseeing there could be even a few more requests than we expect, and being very prepared so that we have the processes in place and the systems in place to make sure that we are able to honor those individuals' rights, especially this right of subject access. Because this is a challenge. It is a huge challenge for businesses. I can not begin to even tell you the number of subject access requests I've turned out. At one point, I was the subject access request person. And just watching how organizations over the years, even though they mature, how they grapple with this area, it just shows that this is a real challenge for organizations. So thank you very much for listening today. As I mentioned before, I do a lot of work around subject access, or have done in the past as well. My team do a lot of work around helping individuals with subject access. I think it's a very important right. And I think it's extremely important that we honor the rights of the individual. But more importantly, I think it's, as privacy professionals, we need to get this right. This is the cornerstone of data privacy laws. Knowing how your data is held, having the ability to understand what's going on with your data is so important. And it's one that we, as privacy professionals, really need to make sure that we're honoring. Thank you very much.
Awesome. Thank you so much for that, Samantha. I think one of the things that really stands out to me from your presentation, which I find is one of the challenges that we face in Jamaica, is just this idea that your back office systems are automated and that you have digital filing systems in place, because a lot of what is required in terms of just internal operational infrastructure so that you are able to manage people's data responsibly is the first hurdle I feel we have to manage. There's still a lot of manual processing, a lot of books. I mean, you go into the standard doctor's office, you know, it's a book, right? Go to the police station, you're signing in a book. Them come with a big, it's a big book is the flipping, right? So I think when you look at even looking at a checklist, and when you're thinking about the levels of responsibility, sometimes persons feel that it's such a leap because they know that the infrastructure that they have to have in place to support that is sometimes a hurdle. So I'm really curious to kind of dig into the side of, well, what's the easiest way to get started? If I don't have, let's say, a database where I can store my info, you talk about a filing system, those are the kind of things that I think we're going to have to navigate in our current environment, because the digital maturity of our organizations is still, I find, the majority of, not all of them, but the majority I find is still in the embryonic stage. And when you're at that place to evolve to responsibility and accountability, it can be daunting. Mm-hmm.
Absolutely. In fact, I have a picture that I took at St. Andrews, at the St. Andrews Memorial Hospital one day, because there was a filing cabinet or filing cabinets with individuals' names on them, and they were categorized in order of illness as well, you know. Mm-hmm. However, it's not that monumental a leap to make. Mm-hmm. Organizations and countries have been making that leap for some time. And I think especially we have to remember in the Caribbean that it's not all glamorous over this side either, right? Okay, we're not the Caribbean is not really far behind. Yeah, many organizations are still using manual filing systems, especially in certain areas of Europe. So it's not that monumental a leap, but this is why I talk about budget. If you're going to be a successful organization, business or other organization within the 2020s, manual filing system is not going to work. It's as simple as that. We are living in a digital society and a digital economy. And being able to comply with these laws, we need to be able to start to move towards having these automated processes and automated filing systems. So how do we start? We start where the journey that I went through all those years ago is that we really start by identifying what do we have. We start moving towards scanning some of that information, but in the main, we're going to find that much of it can be deleted. We can be getting rid of it. And then moving the priority information over.
Okay, thank you for that. And possibly that would address a question from Oliver Holmes, which is in the chat, because we are actually getting ready now to move into our Q&A segment. And we have a question here. In your judgment, how feasible will it be to attract the data compliance function to organizations' existing compliance functions, especially in financial institutions? Is that about the data compliance resource, like as an individual? I'm assuming, is that what the direction of the question, Oliver, just to clarify that, to make sure that we're asking the question correctly. And then I have a comment from Dr. Fraser. Key to implementation is education on the technologies and capabilities in respect of what is best for Jamaica. And I absolutely agree with you there that there is quite a bit of, not just even as far as education, but the awareness piece, which is what we have going on here, awareness and education around what's key, so that persons can know how to navigate it. Okay, so Oliver, I saw that you were attempting to either clarify the question, I believe. And ladies and gentlemen, if we have any other questions, please feel free to drop them in the chat, because we're moving into our Q&A segment now, and we would love to hear from you.
Stacey, while we wait on Oliver to clarify that question, I believe we gave him permission to speak. I understand what Samantha's perspective. I understand your perspective as well when you speak about the digital society. But when you ask where do we begin, we have to recognize that the data protection laws anticipate and accept that in terms of our existing infrastructure, there are manual filing systems. And there are definitely some persons on our side, that is on the Caribbean side, who will never be able to either afford or migrate to an online or a digital filing system, probably not, or let's say in our lifetime, right? Because I don't know that I want to say never. And that's because of the dynamics of how our SMEs work, our economy work. You do have some small, really small, what we would call informal sector, as it were. And they will be required to observe the Data Protection Act. So what do I say in relation to those? I think that is the context in which entities that offer DPO as a service will be able to assist them to maintain good records. And that's where the data mapping, for example, comes in terms of having the assessment and enabling them, helping them to even streamline the filing system that they have so that it is structured in a way that ensures compliance, and trying to get them to the place where they deal with data in a different way. Because I think we have to work with the realities of what we have.
Yes, no, I absolutely agree with that.
I agree, but I have to say that I think there's something else that we're not considering, and that is that also comes at a cost. And so what we find, and this is what the trajectory that we've seen in the past, is that as organizations move forward, they say they cannot afford a digitalized system. And then after a while, when the cost of complying in this way starts to outweigh the cost of the digitized system, then we see them, that's the impetus for them to move forward. So it'd be really interesting, but certainly, Georgia, I agree with you. In the short term, we will still see a lot of manual filing. And that's why the data protection laws have always focused around structured manual filing systems and automated systems. But in the long term, I'm super confident in Jamaica that we will be moving forward so that the Jamaican businesses can compete.
I appreciate that confidence, Samantha. We need more like you. Oliver, I see that you've taken off mute. Are you able to speak at this time?
Yes, are you hearing me?
Yes, we can hear you.
You can hear me, okay. Yeah, the question essentially is, we know that organizations, and especially in the financial sector, are already challenged to come in complying with existing regulations and laws. So as we look at the breadth of the Data Protection Act that's in front of us, do you see existing compliance departments being able to attach these new requirements to their existing compliance function? Or do you see a separate and all new compliance department being established, especially within large organizations, to comply with the breadth of requirements that this new act will bring?
Thanks for that question. Georgia, you want to go ahead first?
In terms of the privacy function, one of the ways that I've always liked to look at it is that it must be there. And in the presentation on Monday, what we were trying to say is that it is going to be added to your existing compliance functions, but it still has to be given its own space because of the accountability that is required. And there is going to be some budgetary considerations, but I think that it can be attached to the existing compliance function because there's no one size for how it will look. As I explained, you just because let us say, well, use the banks as an example. If there's already a compliance function, audit, for example, your external audit, for example, would be a part of that team. So is it that they're going to add a privacy person who will be driving the program and then you build it onto your existing infrastructure? IT is another category of your team that will be engaged. IS will be engaged, legal will be engaged. So it seems to me that the one element that you would definitely need would be that person who is driving the program as a privacy professional. So I think it will fit in with what you are doing. It's just that it has its unique compliance challenges that you will need to be mindful of alongside your existing compliance functions.
Okay, thank you for that. Did you have anything to add, Samantha?
Yes, certainly. I mean, I've been, I started off in data privacy in 1998, between 98 and early 2000s. My first dedicated data privacy role was in 2005. And I was one of very few people in this country who had a dedicated data privacy role. What we see is actually, as in nascent regimes, that the data privacy role is actually, or the data privacy program is bolted onto something else in compliance. Very, very common. So most organizations will already have some kind of compliance function related to their type of business, as Georgia says. Dedicated privacy roles, I don't think we're going to see that in Jamaica 100% for quite a while, because that requires quite a huge demand. And that's where companies such as mine and Georgia's company will be able to really help businesses to shape themselves. But in general, I think there's immense opportunity too to make sure that the existing operations within a company, and especially the existing compliance operations, can take on aspects and the most critical aspects of your data protection compliance, because compliance is an iterative process. It's a journey, not just a destination. And I think that's something that people oftentimes forget, and they think they're going to be whiz bang 100% compliant from the very beginning, and that is not going to happen. What you're going to do is you're going to take parts of the Data Protection Act and say, these are the highest risk for us, and we must comply with these. And then there are other parts that you work towards. And so, yes, I see it being able to be bolted on to other areas of compliance, certainly.
And although this is a segue from what Samantha is saying too, look for companies that are able to leverage the different laws or scope of the different laws. So for example, in our company, I'm there with the European Union. We can reach out to Samantha, who has significant experience, as you have heard, because of her exposure to the 1998 Act, and online as well. We also have Cherie, who is CIPP US. So we try to kind of leverage all of those synergies to ensure that we can provide and push the appropriate packages and the appropriate advice to our different customers or consumers, consuming public. And what is funny as well, that you know that these synergies will work. I've only met Samantha and Cherie online, but we know that we are in this privacy space where we have this special role of ensuring that people understand what is to be done, holding their hands through the process, and we draw from the experiences of each other. So I think that's also important to know in terms of guidance.
Thank you for that. And that actually is a great segue into a question that Juan posed in the Q&A, because you talked about the different places that they had their certifications. And his question is, next to the EU, US, and bigger, stricter privacy laws, in the Caribbean and LATAM region, there are a lot of developments in privacy regulation and also enforcement. What recommendations could you provide to address these challenges with dealing with multiple jurisdictions and privacy laws?
Collaboration, which is basically what I was just saying, that and there's this knowledge chapter that we have, for example, for IAPP, whereby the whole point is to ensure that we have this pool of knowledge of privacy professionals that will keep us up to date with the correct information from the various jurisdictions. So I do not necessarily have to know or be certified in US because I have Cherie. I don't necessarily have to know everything, even though that's my certification in the EU, because I have Samantha. And Juan, I think, is down in the Dutch. Juan, please tell us. I know you are in, I think, the Dutch Caribbean. So if you could help us with that too, because you, I gather, are also a resource that we can reach out to through the IAPP. So if you can put that in the chat so that we know. So that's what we intend to do. One, we intend to create these synergies to ensure that our consuming public is able to benefit from the experiences of those that have gone before us.
And he did drop a note in the chat that is part of the Dutch Kingdom.
Dutch
Caribbean, yes.
Right.
And you're absolutely right, Georgia. This digital age has actually ushered in the need for us to be more collaborative and shift from that mindset of competition to collaboration and build out ecosystems that are going to enable us to build together and approach things together. Because if we think abundantly, there is more than enough for everybody. So it's not like you're going to starve, right? And if we work together, we can achieve much more. And that's also shameless plug, but that's also the path that we're taking for the upcoming BizTech 2021, which is the Caribbean conference, right? And we've shifted it from it being a Jamaica conference to being a Caribbean conference, because compared to the 2 million here, there's 40 million of us in the region, and that's still quite low when you compare it to some countries, right? And there is lots of things that we can do together to achieve more while we, instead of sitting with, I want to keep this for myself, right? So I absolutely endorse that approach of collaboration and think that it is going to absolutely help with building out the ecosystem and ensuring the success of this particular discipline. So I have another question here from an anonymous attendee. It says, is maintaining a log of the DSAR required under the Jamaican DPA?
Samantha, are you taking that?
Oh, I'm happy to. I'm very happy to. Maintain a log of DSARs is actually critical. And there's a reason why it's critical. And that's because it can help us to understand, firstly, we need to be able to track the data subject access requests that we're receiving, but also we need to be able to identify if we may be receiving unnecessarily repeated requests or vexatious requests as well. And so even where it's not necessarily mandated that you keep a log, it's extremely important as an operational process. And there's something that I always say, and that when we get to the stage, even though I'm an attorney, I've been a lawyer for years, when we get to the stage where we're looking at what's legally required versus what's not, when it comes to data, we're already in the wrong game. This is about ethics. This is about making sure that you're doing the right thing. So ultimately, we need to be making sure that we have the operational processes. We have the operational processes in place to make sure that we are able to do the right thing. And that's what the law allows for as well.
So I have an additional add-on to that. If the incident response, I asked them a question about DSAR, if the incident response component is also a part of our Jamaican DPA.
Okay, so what we have been describing to persons is it's the way that you ensure that you comply with the law. So the law is made up of standards, and we talk about how you process data, which is the obligation that is placed on the data, the data processor or the data controller. So those are the standards. And then the data subject has certain rights. And then there are penalties. When you come to assessing penalties, most times they will want to see what you have done in terms of mitigating any of those harms. So that is the basis on which you must, from the sanction perspective, that's the basis on which operationally the best way for you to ensure that you comply with your notification request or notification requirements, or in the event that there is, in the event that there is to be a sanction, that sanction is reduced, is to ensure that you are able to document what you have done. And then remember the last slide that I had, I showed you what the benefits were in terms of the ability to remediate quickly because you have a plan. So it's because we're talking about governance, why anything that you do in governance is best expressed by documents. And documents, I'm speaking broadly, not necessarily meaning paper, but in terms of electronic. So you have to have a process and a process flow and a workflow. So indirectly, you would say that the best way to ensure that you are complying, to demonstrate that you are complying, is to have that workflow and process in place, and that you can demonstrate, because the framework in the Act is built on accountability and transparency, and it must be demonstrated. Can't demonstrate it if you don't have it in writing. That's the best way I can put it and answer that question.
Okay, great. Okay, great. All right. I think we have definitely answered some really interesting questions and addressed really critical points for this conversation around prioritizing privacy, and in particular, getting a better and clearer appreciation for and understanding of incident management, as well as handling data subject access requests. So I want to first of all thank our presenters for preparing such detailed presentations and for sharing with us in such an expert and informed way. I want to thank our attendees who have joined us this evening and those that came on from the beginning and stayed with us till the end. I want to thank you. In particular, I want to just say a big up to Samantha because it is after midnight in London now. So we'll release you to start enjoying your rest. And for the persons from the PLMC team, Shabanice, and also for Shireen, I want to thank you so much for executing an exceptional event this week and for sharing key insights that are also critical for the space. I look forward to seeing everyone that has attended, also to attend the BizTech 2021 conference. Registration is now open. Please check us out on LinkedIn. You can check me out on LinkedIn, Stacey Hines, or the JTVA. We are there. You'll be able to find us. And we look forward to sharing this as well as much more information around technology solutions for the Caribbean region. And that is November 10th through 12th. So enjoy your Heroes Weekend for those of you that are here on the island of Jamaica, and for those everywhere else, good luck and blessings to you. Stay safe and be well. Thank you so much for joining.
Thank you.
Thank you very much. Bye-bye.